It's a privilege. Yeah.
I hear that Taylor may have had some influence in getting you
Yes,
the role.
she did. Yeah, I know. I don't even know if I'm meant to be saying it, but I'm saying it. Yeah, she was a helpful part of the process of the audition, which I found out later after I got it, and that rocked my world.
Was it exciting? Did you have to make some calls?
There were a lot of calls made for a lot of songs in this movie. Honestly, like this movie, I think that like when you see it, it feels like a big, beautiful summer movie, but like we didn't have any budget. So there were a lot of favors and a lot of begging and
Your knees for Taylor?
I mean, honestly, she was with me on this experience the whole time, all throughout it. So like she really lived this with me. Yeah, she was, she's a person who shows up for you, and I'm so grateful to have that love and that support. But yeah, there were other people too that I had to call and beg, and people that said no. But I don't know what that means.
Hi friends, it's Katie from Without a Crystal Ball. Welcome back to my channel. Oh my gosh, there was so much that happened over the weekend because Friday there was a dump of documents by multiple parties in this lawsuit. So there was multiple motions to compel by Blake's attorneys. There was a motion to quash a subpoena by Stephanie's, and then Wayfarer responded in the most mic drop way by finally revealing to the judge the lawsuit, the Van Zam sham lawsuit that they filed in order for Stephanie to get these messages from Jen's phone. Okay. And Blake Lively's team, along with Stephanie Jones's team, so their lawyers, have been fighting behind the scenes with Wayfarer for about a month since they found out about this sham subpoena. There has been a lot of arguments about discovery, what's going to be disclosed, objections to discovery, and you're seeing a flurry of output from these lawyers trying to paint Wayfarer as the ones that are not complying with discovery. When the truth is if you read through the documents and if you tease between the lines, you see that Blake hasn't provided a single document of discovery to Wayfarer. Blake has not provided a copy of the subpoena that she claims was issued in order to obtain the text messages and the contents of Jen Abel's phones to Wayfarer. She has not provided any evidence of damages. Blake has provided nothing. And if you start reading through the lines, you notice that Blake and Ryan are objecting in the same way that Wayfarer is objecting. So they're having arguments, but they're going to a judge right now because a lot of their arguments with Wayfarer about discovery have to do with Wayfarer, Baldoni, Abel, Heath, Nathan, and the like, all objecting to the fact that they aren't going to disclose discovery that is based upon evidence that was obtained through a sham lawsuit. And if they want to explain to a judge how they obtained these medical records or documents about people, or how they obtained these text messages and contents of a phone to a judge through a sham lawsuit without proper notice, have fun. And then today, of course, Stephanie's own lawyer, Kristen, had a hissy fit that they brought up the fact that there could be some criminal activity here. And yes, Wayfarer brought that to the judge on Friday. So I know there's a lot right now in the media about Taylor Swift, and she's finally been subpoenaed, and she's very upset about this. Okay. She's claiming she wasn't on the set. She knows next to nothing. She wasn't involved with casting. All she did was license one song for the film. And she's trying to act like no involvement. I can't believe I'm getting pulled into this by Baldoni. And then Blake is on with her people saying, yeah, those big fat bullies, I can't believe they brought in Taylor. How dare they? This is just a circus. But in the beginning of this video, you see that nobody promoted Taylor, and you exploited her more than Blake during the press tour and during the totality of this film. using her as a dragon and a weapon. Whether Taylor knew about this or was privy to this is unknown, but Blake is the one that brought her into this. No one else. Because Justin didn't have a relationship with Taylor to exploit. Only Blake did. So we knew that it would come to this. We knew that there would be a flurry of motions to compel. I told you guys, this is always what happens in narcissistic litigation. They want to paint to the judge that Wayfarer and Baldoni are the problem, while they're also not engaging in good behavior themselves. So it started on Friday when Kristen Toller, who is the attorney for Jones, sent a letter to the judge. And in the letter, she was running her mouth that Wayfair had subpoenaed their security company, Edgeworth Security. Okay. This is the company that did the forensic extraction of Jen Abel's phone. Over the weekend, I did some research on forensic extractions of phones. And while it's available to the private sector and to employers, technically speaking, even though it's a company issued phone, if you're going to be extracting data that includes personal data from an iCloud or Gmail, they still need consent to do this. And they did this without consent, to be clear. And they want to stop the subpoena of Edgeworth because they're claiming that it's all protected by attorney-client privilege and work product doctrine, meaning it's part of the lawyer's work that they're using to build their case. And so they're not going to turn that over. And they're upset about a letter that seeks to compel Edgeworth to produce documents, communications concerning your relationships with Jones, all documents and communications concerning your relationships with JonesWorks, all communications between you and Jones, and all communications between you and JonesWorks, which is a request for productions 1 through 4. And they said that on March 13th, JonesWorks served objections to these requests to the subpoena, other requests to the extent that they called for documents regarding JonesWorks. They claim that they met and conferred, but they weren't able to resolve this. So the TDLR on Kristen's letter is basically that she wanted the subpoena quashed, that Stephanie was objecting to the subpoena to Edgeworth's because she didn't want to hand over her private information from Edgeworth and her. And then they're claiming that they're privileged through either attorney-client privilege and that all of this is protected by work product doctrine. And all of this was done ahead of litigation that they were doing to try to figure out who defamed Stephanie Jones, right? And they also claim that they're not going to hand things over because Stephanie needs to protect the privacy of her former employees. And she's not going to hand over information about her former employees that would violate their privacy. Okay. Something that she didn't do when Blake subpoenaed her in September of 2024. Now, Kristen works for this large law firm, Quinn Emanuel. They have like over 1,000 attorneys all over the world. And they are known for being feared litigators, using shady, underhanded tactics and being ruthless in their litigation. So that's who is defending Stephanie Jones. People that will go to extreme lengths to defend their clients and intimidate the people that are being sued. So it is not lost on me that all of these filings that are coming in with Jones now wanting to care about privacy, suddenly now she cares, right? And they're acting shocked today because Wayfarer went ahead and told the court about the subpoena that Jones responded to as a part of the sham lawsuit. So they are introducing the sham lawsuit and they are losing their minds now. Because if you think of it this way, these people are spending all of this time filing these motions to compel and like fighting about subpoenas, when the truth is they're the ones that were involved in the subpoena problem. And so they're filing all these documents ahead of the fact that Wayfarer is going to accuse them of abusive process and committing crimes. And that's what happened. So whenever you're following a case like this, pay attention to what gets filed and think about what's coming next. Why are they filing this now? And this is why. So they wrote this to the judge. The crime fraud exception strips the privilege from attorney-client communications that relate to client communications in furtherance of contemplated or ongoing criminal or fraudulent conduct. The exception applies to the work product doctrine. For the crime fraud exception to apply, there must be probable cause that a crime or fraud has been attempted or committed, and that the communications were in furtherance thereof. Courts have long construed the exception as reaching some conduct beyond crime and fraud, such as intentional torts. Courts have applied the crime fraud exception where a party's actions in discovery are found to be calculated and purposeful litigation misconduct. So all of their crying about these subpoenas and Taylor's getting subpoenaed and all of these, it's all abusive and I can't believe they're doing this, even though they're using a real lawsuit to do it, is to get the judge to think they're the abusers when the truth is this is what they told the judge. On August 21st, 2024, Jennifer Abel arrived at Jones Works' office where she was ushered by Edgeworth's security personnel into a conference room, falsely imprisoned by Edgeworth's security personnel via its intimidation and implied pressure coercion, and then coerced by Jones Works' chief of staff and lawyer present in the room to hand over her Jones Works issued cellular phone to Edgeworth's technology personnel, which she was told was solely to facilitate the release of her personal phone number. In truth, and without Miss Abel's knowledge or consent, Edgeworth technology personnel forensically accessed everything from her personal iCloud and email accounts available on the phone, her text messages, emails, personal photos, and delivered the materials to its client, Jones Works, which then had unrestricted access here too. Jones Works acknowledges that it possesses Miss Abel's private communications, includes such communications in its pleading, and admits they were forensically extracted from the phone by Jones Works IT specialist, Edgeworth. As detailed in Miss Abel's responsive pleadings, Jones Works misconduct, including through its agent Edgeworth, constitutes a violation of the Computer Fraud and Abuse Act, because Jones Works intentionally accessed Miss Abel's cloud-based accounts hosted on remote servers by non-parties such as Google and obtained her private data without her consent. A violation of the Stored Communications Act because Jones Works accessed, intercepted, and collected, financially benefited from, and or disclosed Miss Abel's emails and text messages. 3, a violation of the Federal Wiretap Act because Jones intentionally intercepted, used, and or disclosed electronic communications within, to, and from Miss Abel's mobile device, email accounts, and iCloud, and because she diverted those communications to Blake Lively. A violation of the California Penal Code 502 for similar reasons, and an invasion of her privacy. On the same day that she improperly obtained Miss Abel's private communications and data in the days that followed, Jones Works disclosed this information to Blake Lively and or her agents. At the time, Lively was reeling from a storm of self-induced negative publicity surrounding It Ends With Us and saw an opportunity to use the ill-gotten communications to spin a false tale of a smear campaign to the New York Times by cherry-picking and splicing communications which, when viewed in full context, demonstrate an effort to prevent Miss Lively's vicious behavior and malignant persona from overshadowing the film. However, because Jones Works had illegally obtained Miss Abel's communication and then improperly disclosed it to Lively, Lively needed a veneer of legitimacy. This is where they get into what they did on September 27th. And this is the part that has Stephanie Jones's attorneys so upset. On September 27th, 2024, Lively and her counsel here too, Manat, Phelps, and Phillips, initiated a proceeding in New York State Court, Van Zandt Inc. versus Doe's 1 through 10. The sham action, a true copy of the complaint from the sham action is attached as Exhibit A. The sham action was a transparent ploy to manufacture a procedural vehicle by which Lively could subpoena Jones Works for Miss Abel's communications without notifying any of the other Wayfarer parties, including Miss Abel, all of whom lacked notice thereof and were deprived of any opportunity to object. The plaintiff, Van Zandt Inc., is an inactive corporation affiliated with Lively and her husband, Ryan Reynolds, and unrelated to the film. The Van Zandt complaint is devoid of any specific allegations against anyone, much less Miss Abel, relies exclusively on recitation of boilerplate legal jargon, and implausibly alleges that Van Zant is unable to identify its own contractual counterparties. After the sham action was filed, they issued a subpoena signed by Manat to Jones Work pursuant to CPLR 320, the sham subpoena, which permits the service of a subpoena merely upon the commencement of an action, unlike the federal rules of civil procedure. Van Zant Lively did not name any of the Wayfarer parties as defendants in the sham action because doing so would have required service of a copy of the sham subpoena upon them and would have enabled them to move to quash it. As planned by Lively and Jones Works did not object to the sham subpoena as the complaint and the obligations they would be violating, but instead blithely surrendered the entire contents of Miss Abel's stored communications a second time to Lively without her knowledge, and to fabricate a protection of legal process. Tellingly, on December 19th, the sham action was discontinued. The next day, Lively filed a complaint with the California Civil Rights Department, and the New York Times published an article containing Lively's allegations and Miss Abel's private communications. Despite repeated demands, Lively's counsel has failed to provide Wayfarer parties with the sham subpoena. So they're arguing that Edgeworth should not be required to hand anything over, and they're using all of these arguments about, it would violate this and it would violate that. And the crime fraud exception, although this is a good argument, I don't think it's going to get decided on a motion. He might do an in-camera review, which means they bring the evidence to the judge so the judge can see what the sham subpoena was and what the case was and how this could help them pierce the attorney-client privilege. Because if they can pierce the attorney-client privilege here, usually the judge will want to see the full context under the camera review. Basically, this is what they did. And then he can decide, okay, I'll pierce it for this issue. In her amended complaint, Lively represents to this court that she obtained Miss Abel's communication through legal processes, including a civil subpoena served on Jones Works. Jones Works similarly represents that it received a subpoena for the phone's contents. Neither Lively nor Jones Works told this court that the sham subpoena was issued in a case where Lively intentionally omitted herself as the plaintiff to avoid publicity, intentionally failed to name the Wayfarer parties as defendants, or any actual defendants to avoid the obligation to notify them of the sham subpoena. And where Lively had no intention of actually litigating the claims in the sham action. Equally as bad, Jones Works counsel publicly claimed that Jones Works disclosed Miss Abel's communications to Lively in response to a court-ordered subpoena. It's unclear how the sham subpoena could be court-ordered, given that no judge was assigned to the sham action, which would have required that they file a notice for judicial intervention. They're seeking documents concerning Jones Works' receipt, use, and disclosure of Lively and Miss Abel's communications, the facts which are undisputed. The misconduct by Jones Works constitutes tortuous conduct and a violation of multiple federal and state statutes. The sham action and the sham subpoena, which are unquestionably designed to provide a false cover for Jones Works' disclosure of Abel's communications to Lively without notice to Miss Abel or any of their parties, constitutes serious litigation malfeasance. As the Wayfarer parties prepare to seek further relief with respect to the sham action and sham subpoena, we respectfully request court deny the Jones Works motion and compel Edgeworth to comply with the subpoena, or in the alternative, conduct an in-camera inspection of the disputed documents. And then they signed that. Mitchell Schuster, who's with Meister, Sealing, and Fine, signed that. And then he provided a copy of the Van Zant Inc. lawsuit and a copy of the dismissal where they withdrew it and never added defendant. So they're telling the judge now a couple things. One is part of our issues with discovery right now have to do with how they obtained evidence. They obtained evidence that are outside of the federal rules of civil procedure. And the way that they did this subpoena is not allowed in federal court, which is true. They're outlining why this case they believe is abuse of process. They're tying it to the specific charges that they have against Stephanie Jones in the lawsuit of Jones versus Abel, where Abel countersued for wiretapping and the computer storage data violations and computer fraud and abuse. So this is being strategically done now because they're accusing, obviously, Wayfair of properly subpoenaing someone who has evidence that they did the forensic extraction. And to be clear, there are extraction and security companies that can do this, right? But the kind of data extraction that was done by this security company is usually reserved to law enforcement. Law enforcement is who uses these kinds of services. And generally speaking, in order to forensically extract somebody else's phone, you need their consent. And you need their consent because even Edgeworth and even Cellbrite, the software that they use to extract this, they have a disclaimer on their website. Cellbrite does that if you don't have the permission of the person that you're extracting the data from, you are vulnerable to claims of crimes under the Computer Storage Act, which is what they're bringing claims against, and invasion of privacy. So Wayfair is well within their rights to bring these actions against them. Obviously, Jones and Lively are having a hissy fit because they don't want this exposed in court. Not only that, but Wayfair is upping the ante here by not just saying Jones and Lively did something that was illegal, but they used their attorneys in order to facilitate this fraud. And it's unethical and a violation of the codes of conduct of an attorney to participate in the aiding and abetting of a client's crime and using the court system to abuse the court through abusive process, frivolous litigation, sham subpoenas, sham lawsuits. And so they are telling the judge, like, listen, it's not just Jones that did this. Her attorney that's writing you this letter lied publicly that this was from a court-ordered subpoena because it's unclear how it would be court-ordered given that no judge was assigned to the case. So by calling it a tortuous conduct, they're saying we can sue for this. We can bring civil and criminal charges against them for this. And they're saying it's a violation of multiple federal and state statutes. So it's, again, we can sue for this and we can bring criminal charges against them for this. And we are going to continue to review all of our options. The misconduct puts Kristen's choices to publicly lie and say that this was a court-ordered ethical lawsuit. It puts Manat and Kristen at risk of being disqualified from the case, removed. They can seek removal of them from the case. They can report Kristen and Blake's team to the bar for sanctions or disbarment. They can seek sanctions from the court. And most importantly, what this letter tells the judge is that this evidence was obtained illegally, and we believe that they should not have this evidence because it was a violation of the law, and it violated the federal rules of procedure, which is true. So if you get evidence in state court that does not follow the rules of civil procedure in federal court, that evidence can be deemed inadmissible. It can be thrown out. Judges can actually dismiss the entire case because of that. And so this filing to the judge is like not only like crime fraud exception, but judge, listen, you've got a bunch of motions to dismiss you're looking at, and we want you to know that these people don't even have a case against us because of how they got their evidence and put it in a way to make it look like we did something when we did not. If you're going to commit a crime or willing to commit a tort in order to get evidence, it becomes a huge problem. So naturally, Kristen ran to the court this morning and started crying to the judge that this was never brought up to her. It says, pursuant to Rule 4C of this court's individual practices, they respectfully request a leave for the court. They said a mere 2 hours after Jones Works filed its letter motion for a protective order to prohibit enforcement of a subpoena served on a third party, Edgeworth Securities Services, that plainly seeks Jones Works privileged documents, the Wayfarer Parties filed a 3-page letter motion seeking to invoke the crime fraud exemption to overcome that privilege. During multiple conferrals over the course of more than a month, the Wayfarer Parties did not once mention the crime fraud exception as a possible basis for overcoming Jones Works' well-founded assertion of privilege. I just checked the rules of civil procedure, and no attorney is required to ever disclose to the opposing counsel that they will be seeking the crime fraud exception. They didn't have to tell them. And in her original letter to the court about these subpoenas, in fact, she wrote to the judge that Wayfair stated that they have narrowed the request to only documents relevant to this litigation, but stated their intent to pursue the subpoena despite the privileged nature of the documents sought. So they told them they still wanted these, and he was under no obligation to tell her that they would invoke this at some point in the case. It can be invoked at any time in the case. Her argument to the judge is that in hiding their intent reveal that the pre-baked opposition to Jones Works' motion is without merit or good faith basis and appears primarily designed to further their outlandish media narrative against Jones Works. So their claim is that it's defamation for them to claim that Jones Works handed over records as a part of a sham subpoena and a sham lawsuit, an outlandish media narrative, a gaslighting response from Kristen. I've never seen an attorney ever kind of do this kind of lawsuit and then accuse the other side of using media narratives. And it says because the Wayfarer parties concealed their intent to raise the crime fraud exception in relation to the subpoena and failed to raise it on any conferral, they of course had no opportunity to address the issue and its inapplicability to the present situation. And this type of sandbagging and litigation by ambush is precisely the type of conduct the court has recognized warrants permitting a reply. So she wasn't prepared to consider the fact that they might use this as an idea or as a way to get around attorney-client privilege. She never thought to consider the crime fraud exception was something that could be warranted here. This is just like having a temper tantrum for the sake of having a temper tantrum. And they're saying that they will reply that the facts stated in the Wayfarer party's response are false. They and their counsel knew they were false when asserting them to the court, and their invocation of the crime fraud exception is patently frivolous, including because they failed to present even one iota of evidence to substantiate their false assertions, despite acknowledging that they must do just that to support an application of the exception. And they're abusing the court's docket for extrajudicial purposes, including to launder defamatory statements. Kristen is trying to claim that they are introducing new evidence through the reply brief, but they really aren't, because they referenced their lawsuit against Jones and the claims they made against Jones. And in their counterclaims against Jones, they specifically told the judge about the sham lawsuit and the sham subpoena. This is the first time the lawsuit and the subpoena have been introduced into court, but it's not as far as an exhibit, but is not the first time it's been brought to the court. It doesn't seem like sandbagging to me, but again, it's faux outrage. Okay, so do you know what she did there? Wayfair has accused them of using the sham lawsuit to launder illegal evidence and make it legal. And now she's trying to flip this on them and say, you know, that's not what we did. She's trying to justify the use of this lawsuit. She's trying to say they know that what they're saying is false. And she's trying to accuse them of abusing the court system because they accused her of abusing the court system. This is the classic retaliation that happens anytime you bring an issue to the judge with a malignant narcissist and the attorney that represents them. It says, this acknowledgement further supports the fact that Wayfair's response was employed strategically, not as a serious opposition to the motion. To be sure the parties had evidence, they would have presented it rather than recognize and ignore a requirement, the failure of which defeats their objection. She's panicking, and she's going to try to rewrite the narrative by accusing them of defamation. Anything that you file in court is not defamatory, by the way. And the fact that she can level and say whatever she wants about Justin and all these other people, and there's no consequence. But if they do it to her, it's like she has a temper tantrum. And she's having a temper tantrum because she's been called out to the judge. I can't wait to see how she defends this. And it's going to be more gaslighting, clearly, a lot more gaslighting. But the judge now is on notice. He has a copy of this lawsuit now. He can see the actual boilerplate jargon, and we can see how it has nothing to do with Baldoni or Wayfarer. It also has nothing to do with Jen Abel or Stephanie Jones. To add to this, on top of Kristen having a meltdown, Ezra Hudson is having her own meltdown of sorts. And she is trying to tell a judge that we need to compel the Wayfarer parties to provide a copy of their damages. And in the letter that she sent to the court, she provided a letter of the meet and conferral. So the crux of her entire letter to the court is that they must produce financial information to them to prove damages. They want them to provide financial losses, including lost profits. They refuse to produce the requested documents bearing on the loss. They've refused to respond to each request, inserting kitchen sink objections to burden, an attorney-client privilege, but not tax privilege, and that they must provide these documents. And they're claiming that they don't have a right to claim financial harm, but then refuse to turn over specifically requested financial records in favor of some unstated alternative set of documents they subjectively deem sufficient to demonstrate damages. In fairness, they said that they were willing to provide financial records, and in the evidence she files to the court, she's ridiculous. She provides a letter of this meet and confer, okay? So Ezra is trying to say, listen, judge, they're claiming damages and they're saying they're not going to provide any damages to the court. Now, I've gone through litigation and I've had the same problem with damages in one of my cases where the defendant or the plaintiff refused to hand over any damages after claiming that I had damaged them. And they never did. They never provided their tax returns. They never provided any documents, period. So they couldn't prove we couldn't prove that we actually caused harm. And we had to do motions to compel. But sometimes in cases like this, if your opposing side is not cooperating and also not providing you evidence or discovery, attorneys can get into sort of a stalemate where they are like, well, I'm not going to provide because you haven't provided. And until you hand over documents to me, I'm not handing over documents to you because they're still playing this sort of game of chicken in discovery where it's like, are you really willing to go all the way through court? Are you sure you don't want to withdraw these claims against us? Are you really sure you want to go there? So if you're being compelled, say, oh, well, they have to provide, if the judge says both of you have to provide, and then if neither one of you do, it's like, well, you both failed, right? And in this case, neither side has provided any damages to either. Blake has not provided any evidence to the court, to discovery, to Wayfarer at all. And so they sent this email, and it's not just about financial stuff, which is weird, right? And so the motion to compel is only talking about damages, and yet the email that that they sent for the meet and confer is about their evidence in the case and Wayfarer fighting with them about it. And this might help you understand why this is going this route. And it's because of, again, the sham lawsuit. First of all, we learned that Lively and Reynolds are basically refusing to give up anything based on boilerplate and kitchen sink objections. And they'll stop doing it if they stop doing it. That was the agreement they made. And then they also asked for a bunch of information about damages, okay? And in what they spoke about, this is how Blake's attorneys summarized it. We requested your legal basis for withholding documents in response to requests that bear directly with Wayfarer Parties' alleged damages, including but not limited to alleged compensatory damages of or exceeding $400 million. You stated that the basis for these damages amount was scope, but failed to otherwise explain how the scope of these requests justifies your outright refusal to produce any responsive documents. Your response that you don't know what documents support the Wayfarer Parties' alleged hundreds of millions of dollars in damages is insufficient to overcome your obligation to produce documents in response to these requests. The financial information sought in these requests is unquestionably relevant to the Wayfarer Parties' defamation, extortion, and tortuous interference claims against both Ms. Lively and Mr. Reynolds. Ms. Lively and Mr. Reynolds are entitled to understand the financial harm they are alleged to have caused. Indeed, the financial information sought is the exact sort the courts deem relevant in cases such as this. Compelling production of financial statements and tax returns in action alleging intentional interference with contracts and advantageous business relationships. They're also narrowly tailored both in time and in content sought. Please advise if you're willing to reconsider. And this is how Kevin Fritz, who's one of the attorneys, responded. Your recitation of the conversation is incorrect and incomplete. When asked to explain the relevancy of the categories of documents sought by the request, you replied, damages. You failed to explain, because you cannot explain, how documents concerning net worth or liquidation of assets are relevant to the damages incurred by the Wayfarer parties. Furthermore, I advised you that the Wayfarer parties will produce non-privileged documents concerning their damages. I further advised you that if upon receiving such documents you believe the additional documents should be produced, you should notify us of that position. We agreed that this was an acceptable manner of proceeding. So it sounds like in the meat of conferral from Wayfair side, they said, well, we are actually wanting to know, why do you need to know about our net worth? Why do you need to know about our liquidation of assets? Because he liquidated 100 million. They're really concerned about that. Sarowitz did in stocks. And so he's not saying they're not going to comply. He's saying that they will comply. And so now they're going to the court and saying we won't comply, but he just said they would. So it'll be interesting to see how they respond to that. But something they didn't bring to the judge, I thought was really wild. So they're asking him, request number 60, and these are a lot of requests, you guys. They are overwhelming Baldoni with requests. You said Mr. Baldoni will not search for or produce documents or information responsive to this request. Request 60 seeks information regarding Mr. Baldoni's asserted neurodivergent conditions, which he admits he was communicated about in connection with Miss Lively's allegation and has relied on to explain his alleged sexual harassment, retaliation, and other inappropriate behavior on the set of It Ends With Us, which is not what he did. This information is demonstrably relevant to Miss Lively's claims, including but not limited to her claims of sexual harassment, retaliation, and violation of Title VII, fair housing, blah, 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 argument, and without support does not relieve them of their obligation to produce responsive non-privileged documents. It is also relevant to Mr. Baldoni's alleged conduct in influencing the public's narrative regarding his conduct on the set of the film at her expense. So what they're seeking is information on a medical condition that they found via a text message through the illegal sham lawsuit and sham subpoena. And Kevin says this, your recitation of the conversation is incorrect and incomplete. When asked to explain the relevancy of the health-related documents sought by request number 60, you replied, it's in the discovery. I then asked you to what discovery you were referring. And at that point, you realized that one, no discovery has been exchanged between the parties in this action. And two, you should not have referred to the discovery that your firm obtained through the New York State court action in which, from our viewpoint, you purposely omitted Lively as the plaintiff and listed her company Van Zandt as the plaintiff and purposely omitted one or more of the Wayfarer parties as defendants so that no one would know that Lively had, in essence, commenced a lawsuit, and B, that Wayfarer parties would not receive notice that Van Zandt had been served, aka Van Zandt Inc. Lively had served a subpoena. In an effort to retreat from your reference to such discovery, your colleague Michaela then referenced to Lively's allegations on page 60 of her amended complaint. However, paragraph 188 of page 60, which you cite above, purports to quote from a text message that appears to have been obtained by your firm's response to the Van Zandt subpoena. In other words, both you and Michaela were referring to the same discovery that you obtained without notice to Wayfarer parties. If your firm wants to explain to the court how your firm obtained information concerning Baldoni's purported medical condition and attempt to explain how it is relevant to Lively's claims, we welcome the opportunity to respond. Mic drop. It's funny that they didn't tell the judge that part. You need to compel them to give us the information about his medical conditions. You need to compel them, but they didn't. They didn't compel them. They only want the financial records now. So they're not going to tell the judge, you need to compel them for the giving us evidence from discovery from a sham lawsuit that we got our evidence for this case. Behind the scenes, it would appear that they're fighting back on a lot of discovery because the evidence that Blake Lively and Stephanie Jones obtained was illegal. And they're just kind of baiting them to tell the judge about this. And because Wayfarer is planning on taking other action against them, which I don't know if they've already stated there's serious civil allegations that they can make. And then they've also claimed that there's criminal charges they can pursue. And all of the attorneys in this case on the opposing side of Wayfarer are on notice that that's what they're considering. And so all of these attorneys are just panicking, in my opinion. We'll ignore the fact that we did this evidence illegally, but please, judge, hand us over the damages so they can look like they're not complying. It's such a game. And then they accuse them of strategy and dumping it in a reply brief, which, by the way, anyone is entitled to bring up in a reply brief the crime fraud exception if the person seeking the quashing or productive order is hiding behind attorney-client privilege. So he doesn't sandbag. He's just using the exception strategically because she's not wanting to hand over documents that she literally handed over to Lively with no problem. But now she doesn't want to hand over anything. It's such gamesmanship. And in the middle of all of that, you've got this whole Taylor Swift issue that's been erupting online. And it's all just a distraction. There's all these screaming and yellings by Blake's side about subpoenas because they don't want the public narrative to become this sham subpoena. And then they're calling it defamatory. How is it defamatory to point out the truth? That's how you know you're dealing with a narcissist. I'm sure these attorneys are dealing with clients that are brutal and just telling them to do whatever, and the attorneys are trying to throw whatever they can at a wall at this point. But at some point, you'd have to tell your clients that they need to consider settling because they have no case. Because right now, the further they go into this, it would appear that Wayfair is prepared to take all legal remedies, including filing criminal charges. So what are your thoughts? Let me know in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye, besties.